Are they do you like those pancakes? Are they cooked to your satisfaction? What are you doing? I'm like,
what a difference. 2.53 seconds on the first shot, outstanding, and your shots are dead on target. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I want to let you know that that sound you're hearing in the background through the entire interview I'm about to do is the fan that's right over there. And that's because this is the one room in my house that seems to get hotter when all these lights are on, and we're having a bit of a heat wave, so I've got a fan running, so please ignore that. I've got Cody from the Firearms Policy Coalition who's going to join me today. I'm going to say his name is Cody Wisniewski, and I'm hoping I haven't messed that up. I guess he'll tell me later if I have. This man is extraordinarily bright, and he knows a lot about the legal beagle stuff and history. They're a great organization, so we're going to talk about a lot of things today. It's a very exhaustive interview. Fortunately, he's agreed to come back on the show periodically. I'm looking forward to that. All right, without further ado, I do want to mention that YouTube is becoming more censorship happy. So if you're watching on YouTube, I urge you to go to X and Rumble and follow me over on one or both of those. Rumble, all of the videos will be over there, and even videos I can't put on YouTube are going to be on Rumble. X, all of the videos are there, and also you get to hear me prognosticate and be snarky or whatever. That's an uncensored place where I voice my opinions, probably more than I should, be honest with you. But you can find me there as well, and there are links in the description. All right, let's go talk to Cody. Cody, thank you very much for joining me, man. It's the first time on the show. I'm really grateful that you came on. Thank you very much. I know I've been chasing you around the planet trying to get you on the place. I'm really glad you're here.
Yeah, thank you for having me. Yeah, I've been jet setting quite a bit lately, so I'm glad we were able to find some time to sit down.
You've been flying around with Elon Musk, looking at SpaceX and other stuff. You're supposed to be fighting for our rights with FPC. What are you thinking? Jeez. Hey, I wanted to ask you about that real quick, and I'm sorry I interrupted you. I apologize. FPC is like two organizations, sort of, but not. So you're president and CEO of one, but not the other. How does that work?
Yeah, so FPC, Firearms Policy Coalition, right, the brand that most people are probably familiar with, is a 501c4 membership organization. You know, that's the bread and butter that most people are, like I said, familiar with or talking about. FPC is a plaintiff in just about 59, it either is a plaintiff or it's supporting about 59 active lawsuits across the country. It's the one that's using all the fun words on Twitter that everybody's following along and resharing. I am president of FPC Action Foundation. FPC Action Foundation is a 501c3. We're obviously related. And basically what we do is we either represent FPC or we help FPC manage its litigation. And so we work intimately with FPC on, those 59 active cases that FPC is either a plaintiff in or supporting. And we make sure that those things are going how they should be, and that we are making strategic considerations across that entire docket.
Now, you are an attorney, if memory serves me correctly, and you went to UC San Diego, didn't you?
I went to USC.
You went to USC. You went to, okay, so but you were here in San Diego.
Yes, yeah. I went to University of San Diego for law school, so I'm originally born and raised San Diego. I left for a brief stint in Canada because California wasn't anti-gun enough, so I needed some more experience. And then moved back to California for law school, and then fled shortly thereafter. So.
And where are you now?
I'm in Tennessee now.
Oh, you're in Tennessee. Okay. Well, my wife and I fled half. We kind of sort of halfway fled to the White Mountains of Arizona. So we have a place out there, but we live here in San Diego as well. So we're still stupid. You're really smart. Well, listen, you talked about my audience is really familiar with certain organizations because I've had a bunch of them on here. Yours has never been on, so I'm hoping that you will come back again and again and again. So if you can tell us a little bit about, the organization. You're involved in a lot of lawsuits around this country, not just in California. So perhaps because I'm in California and you're a San Diegan of sorts, can you tell me what's happening in California and what part FPC has played in that, and then maybe we can talk about the rest of the country?
Yeah, absolutely. And our focus has always been litigation, right? That is our bread and butter. That's where we work. That's what we do. A lot of people have focused on lobbying. FPC, as a C4, has done some lobbying in the past. But really, our focus is on litigation because through litigation, you can set, broad sweeping precedent that is applicable in all of these different places, right? If you sue in California, you can then go up to the Ninth Circuit and have it applicable in every state of the Ninth Circuit. You can then potentially go up to the Supreme Court and have that precedent applicable nationwide. And so litigation offers you that ability in order to do that. Now, because of that, though, litigation is expensive, litigation is difficult, and you have to be able to focus on a lot of different issue areas at once. And so, as you mentioned, we have cases nationwide. Some of those cases across the country will affect Californians, but we also have a significant number of cases in California. FPC was originally started in California, and we do have a pretty big docket there. So probably the most recent opinion that your viewers, listeners will have seen is the case coming out of the Ninth Circuit on California's so-called sensitive places bill, which was their response to the Bruin opinion. And in that bill, California basically designated everything that it could possibly designate as a so-called sensitive place in order to prevent concealed carry holders from being able to carry in those places. So we don't generally expect a lot of good opinions to come out of the Ninth Circuit. And so we were, pleasantly surprised that the Ninth Circuit actually, we had an injunction from the district court that prevented the state from enforcing parts of its law. And we were actually pleasantly surprised that the Ninth Circuit upheld, big parts of that injunction, ensuring that the state is still prevented from enforcing parts of that law. The Ninth Circuit also reversed parts of it. So there are some areas in which now the state can enforce it. But that's probably been the biggest, movement or news coming out of, California Ninth Circuit recently, just to see the Ninth Circuit kind of maybe shift just a touch to.
Well, let's talk about that one. Okay. So, and then we'll talk about the national stuff and the other thing. Yeah. That one is sort of a convoluted mess. Of course, the whole law when they tried to pass it was a convoluted mess. It was almost, in fact, it was entirely unnavigable by anybody carrying a gun. You couldn't. There's no way on earth that you could carry a gun, try as you may, and somehow not run afoul of that stupid thing and end up in a sensitive place. And so obviously if you're carrying a gun in California, number one, make sure it's concealed because you're going to accidentally find yourself in a sensitive place no matter how hard you try not to. But even with the things that they left, that the judge overturned, that he left in place as far as things that can be enforced, I think about the restaurant thing. Okay, so if you're in a mall and there's a restaurant in the mall, you're not supposed to be in the parking lot. Does that parking lot extend to the entire parking lot of the mall or just the parking lot of the restaurant? This is kind of a nightmare. I mean, these things it gets very, very tough. Fortunately, yeah. I've talked to a lot of police officers about it, and I have yet to find one who's willing to enforce it, so they're not looking for people violating the law. I think if they stumble on you, they'll get you, but otherwise not. But where do you think this is going? Have you guys fleshed out at least what the rules are for concealed carry holders, where they can go, where they can't go, and some of this extraordinarily gray stuff that leaves them, frankly, really wondering? I wonder, for example, about retired police officers. Does this apply to them or just to folks that are carried with a concealed carry permit? Does this apply to the security guard who gets a job and carrying a gun and he's going to be working in a building where there's a restaurant? Can he actually go to work? You see what I mean? This is confusing stuff. What are your thoughts?
Yeah, absolutely. And that's the problem, right? Is California doesn't want it to be clear. They have no incentive for this to be clear. They're not trying to make it easy for people to be able to exercise their rights and to be able to carry firearms. So, what we always do is we always let people know what's going on in the case. We give you an update of where it's at, and then we point directly to the court's order. And in this one, there is some clear language towards the end of the order that talks about, what portions of the law remain enjoined, what portions don't. Now, the other part is, you mentioned, right, I'm an attorney, but I'm not your attorney, and I can't represent you. So it's one of those things where I can't necessarily tell people, yes, you're good to do this. No, you can't do that, right? Like as an attorney, I'm limited on what I can and cannot tell people. But we always point people directly to, and we always provide the text of the order so that people can go and look for themselves, or so that they at least know what they can take with them to talk to their attorney or their CCW instructor or their people, law enforcement. Some people are comfortable doing that, and try and give people the resources so that they can make those decisions. What I will say is the Ninth Circuit's decision is very convoluted. It also, in its reasoning, I know I just said that the end is clear, in its reasoning, and it bounces between a lot of these different areas when you're talking about hospitals, public transportation, public gatherings that require a permit. And even in the provisions that it strikes down, it still leaves this gap. The reasoning isn't accurate. The reasoning is still very problematic, right? Like, so for example, on public transit, the Ninth Circuit struck allowed the injunction on preventing the state from enforcing its ban on public transportation to stay in place. But the only reason the Ninth Circuit gave was, well, it's a blanket ban, and there's not a provision for if firearms are, stored, locked, and unloaded. So I'm not exactly sure how you're supposed to bring your locked and unloaded firearm with you on the bus. I guess you just have to schlep your safe around with you at this point. But basically what the Ninth Circuit did was it said, well, California, your law doesn't provide for this, so thus we have to leave the injunction in place, but wink, wink, nudge, nudge. And so there's definitely a little bit of, well, if the law said this, then we would probably uphold it. So it's certainly, I'm not going to color a Ninth Circuit opinion as being, brilliant or grand. I said we were pleasantly surprised. It didn't, we weren't necessarily ecstatic.
Well, I think the pleasant surprise was the fact that we at least won on some.
Yeah.
Because I don't know about you, but I was not expecting us to win on anything. So
yeah. And here's what's really interesting, and this is something that I think that people are taking for granted, especially in this space. So, before I just did Second Amendment work, I also worked in, the kind of liberty movement writ large. I did environmental law, Endangered Species Act stuff. I'd worked in, organizations that have been around for decades. And one thing that we're seeing in this space, and that we're seeing so quickly, is this adaptation. A lot of courts are doing it incorrectly, but this adaptation of the text and history test, in legal terms, we would call that originalism, right? That the Constitution means what it said when it was drafted and ratified. It's a remarkable concept. It's only that's how we interpret every contract that's ever been written. But in the constitutional law space, going to originalism wasn't a thing 20, 30 years ago. It was just becoming popularized. But even the Ninth Circuit, in its opinion, in here, for example, talking about the private property rule, right? This so-called vampire rule, guns are banned unless you have express permission from the private property owner. Even in discussing that, the Ninth Circuit is forced to tangle with the text and the history. Now, they get the history wrong. The circuit draws an analogy between a 1771 New Jersey statute, which they have incorrect, and an 1865 Louisiana statute, which they also misinterpret, and claim that those provide a basis for California, or would provide a basis for a state to enact such a rule. They actually upheld the injunction against California solely because California didn't allow the property owners other means to give permission. It's only based on the specific sign from the statute. And the Ninth Circuit basically said, well, history says that they could have given it verbal permission, they could have given written permission. And so because California doesn't allow for those, the injunction stands. It's just kind of not but the point there is that they still misinterpret history. They're misinterpreting that 1771 law and that 1865 law. They're allowing for an analogy to stand that shouldn't, based on two laws, only one of which is at the founding era. So the Ninth Circuit isn't doing history well, but it's forced to do history, which is a monumental jump from where we were, pre-Bruin, and all we were doing was interest balancing. And we see other courts that are still engaging in interest balancing, but it is really interesting to see panels of the Ninth Circuit be forced into originalism in a sense.
Do you feel like this is a good omen for us, that they're getting it wrong, but at least they're forced to try?
I am perpetually the optimist on this. I do think that is a good omen. I think the fact that even the judges that are deciding against us are forced to do so via originalism is a net benefit, because the more that we get into this history, the better and better judges and parties and individuals are going to be with that history. And then the harder and harder it will be for anti-gunners to avoid that. And I do think that it is a net positive overall, and I think that that's a good tide that we have in the space.
You guys are involved in cases all over the place, and I know that one of the things, just anecdotally, that I've seen over the last, I'm an old dude, last decade or so, particularly I think very recently, is that organizations are working together more than they used to be. I mean, they used to be all, they're always arguing over funding, and they're competing for funding, and they're competing for membership and that kind of stuff. But what I see now is so many organizations are joining hands in fighting these lawsuits. I don't know whether that strikes me as something that's just born out of necessity, but I really don't know. I guess my question would be, as you look forward to where we go with that case in particular, knowing that there are many choices, is this a conversation that's happening between and with other organizations, or because I think there's 3 cases tied together in that thing, or is everybody sort of going their own way with their own case, figuring out what they're going to do?
I mean, there's 2 points there. First is, I don't think it is something that's just born out of necessity. I think this is something that is a concerted effort. I think, we, at the end of the day, we want to win, and we're all fighting for the same end state, right? Or at least pretty close to the same end state. And so when there's opportunities for us to work with other organizations, for us to, partner on things, for us to support other organizations where we can, we're excited to take those opportunities. We're happy to build coalitions. We're happy to be part of coalitions, whether that's, filing a lawsuit with a group of other advocacy organizations, which we've, done several countless times, really. Well, I suppose you can literally count them, but the expression stands. And or if it's, filing an amicus brief in a case to support somebody else's work. I think that those things are really important. So I don't think it is something that's born out of necessity. I think it's something that is very intentional of, let's work together, let's get on the same page, and let's push forward. Now that's, sometimes people have different claims. We'll have maybe not conflicting lawsuits, but we'll have different paths forward. So we're always working and trying to walk that narrow path. In a case like this, where there are other cases involved, of course, we'll communicate with the other counsel. Our attorneys on the case will communicate and make sure that we at least know, everybody knows what's going on. That doesn't mean we always have the same path forward. That doesn't mean that we aren't, kind of sometimes forced into decisions based on what's going on in a case, but we'll certainly communicate. We're certainly happy to keep those lines open and make sure that, we know what's going on and that we're pushing for what is best for the case and what is best for the state of the law at the end of the day, because that's what's most important.
What do you think the path forward is with the sensitive places case? It strikes me that, I'm not an attorney, but it does strike me just from kind of watching what attorneys do that you have some various options. Where do you think it's going?
Yeah, I don't know just yet. We're still reviewing the opinion. We're still discussing. I don't know that a decision has been made just yet, but there are paths forward, right? There's a potential that you can let the opinion stand. Any party can, push and move for en banc, asking a bigger panel of the Ninth Circuit to hear, since the Ninth Circuit is unique in that there's never actually been a full en banc case before the Ninth Circuit. I doubt that that's going to happen today. So, you could go that direction. It could also, of course, the Supreme Court is always a path forward, although they're more interested, it sounds like, in taking merits cases than cases on appeal from injunctions right now, preliminary injunctions. So those are all viable paths forward. We'll discuss with counsel. Counsel will discuss with other counsel, and we'll do our best to see what we can do to put everybody in the best position for the future, and that's usually our goal.
So if I ask you to put on your prophet hat and prognosticate, or just opine, either way, do you think that we eventually win this, so that these types of restrictions that are so onerous and obviously meant to make the few states that still require permits, to make those permits as useless as possible? Is it going to be a win at some point, or are we going to be stuck with this long term?
I think there is a win some point. So I think that this directly flows from Bruin, right? And in Bruin, the Supreme Court specified, you can't just make everything a sensitive place. They talk about Manhattan, like the island of Manhattan, New York, cannot be made a sensitive place just by fiat of the government. So I do think that we're marching towards a victory, and I'll get a little in the weeds on it, but the history supports that too. So we know that there's not a historical record that supports these crazy broad prohibitions on carrying arms in all of these places. The laws that the laws that the Ninth Circuit pointed to in this case, the 1771 New Jersey law, is specifically a hunting ordinance where property owners could prohibit, so for the private property rule, where property owners could prohibit people from possessing certain arms on private property during hunting season in the time of that season. And so that's clearly not analogous to the government broadly saying, well, you can't carry in private property unless you have explicit permission. Those are two very different things. That's the only founding era law that they point to. The next law they point to is an 1865 law coming out of Louisiana that covered the ability of private property owners to broadly, or the government to broadly prohibit the carriage of arms on plantations in 1865 Louisiana. I think we know what that law was aimed at, right? It's very clearly not analogous to California's. The only thing that you could draw from that is that California is equating California residents to slaves, and that's about the only thing that you could possibly draw from that. It very clearly does not apply in today's world. It very clearly was designed as an abhorrent attempt to prevent people from being able to possess arms to protect themselves in a very particular place during a very particular time. And so it's just clear that there's no analogous historical regulation here. And like I said before, seeing courts focus more and more on the history means that these things are going to come out. It's going to become more apparent. It's going to become more of the conversation. And California has been blatantly relying on these insanely, racist and discriminatory laws to support its gun control since Bruin dropped.
Well, I don't think they have anything else. I mean, You're right. I mean, it just seems to be like a recurring theme, and they keep getting called out on it, and they keep doing it anyway. So it's abhorrent, and it's disgusting. But I don't think they mind being abhorrent and disgusting as long as they have an opportunity to win. So that brings up a question, because this has been a debate since the Bruin decision dropped. What is that time frame? Is that 1791 to 1868? Is that 1791 to 1945? It would seem to me it has to be close to around the time of the establishment of the Second Amendment and the establishment of the 14th Amendment, but I don't know. So has anybody actually, as the Supreme Court, any court actually said, okay, guys, when you're looking for analogous laws, you gotta find them within this time period, because out these outliers over here are the ones from Great Britain from the 1500s simply don't apply. What is the range?
Yeah, the range is the founding era, right? The range is the ratification of the Second Amendment, 1791, and within relation to that founding and the ratification of the Second Amendment. Interestingly, so in the thing that has brought this discussion has been that, in Heller, there was some discussion and reliance of laws leading up to the ratification of the 14th Amendment. Of course, in McDonald, obviously you get, the application of what we call the incorporation doctrine, which is basically just the Supreme Court saying the Second Amendment applies to and against the states via the 14th Amendment. There's a split as to what part of the 14th Amendment, but that's a scholarly conversation for another day. But so in Bruin, the Supreme Court basically said that there is a scholarly debate as to the appropriate period of time, which is true. There is a scholarly debate. What is clear is if you look at Supreme Court precedent surrounding the Bill of Rights and other rights that are protected by the Bill of Rights or protected under the Constitution, the court has already resolved this question. The court has already said that, laws surrounding the ratification of the amendment in question are what are relevant to the interpretation of that amendment, if there's anything left after plain text. It's done this in the First Amendment context. It's done this in the Fourth Amendment context. It's not really an open question as a matter of law. So whether there's a scholarly debate about the appropriate period or not is irrelevant to the court. Also, functionally speaking, the court has noted on several instances that the rights protected by the Second Amendment were the same, were understood to be the exact same during the ratification of the 14th Amendment. So even if that period of time was relevant to interpretation of the Second Amendment, it still would be functionally irrelevant because the right was understood to protect the exact same thing during that time. And you can't bring in these offensive and discriminatory slave state laws in order to justify modern gun control regulations. We recognize that those are abhorrent. And so if you remove that category of laws from that period of time surrounding the ratification of the 14th Amendment, the history isn't significantly...
There aren't any after that.
Yeah.
I mean, that's it, babe. You just took them all out. Okay, so this, I want to make sure I'm drawing a beat on this, okay? Because I'm not an attorney. I'm just a business owner, and I'm your average Joe gun guy, okay? So just assume I know nothing, and you're probably safe, okay? When we're talking about the founding era with regard to the Second Amendment, that's 1791.
Yeah.
Have I got that right?
Correct.
Okay, and this whole desire to extend it out to 1860-something is because in that time, that's when the 14th Amendment conferred the Second Amendment to the states rather than just the federal government. Did I get that right?
Mostly.
Mostly. So, okay, help me understand that, because to be honest with you, I mean, I realize we're in the weeds a little bit, but this, I think, is important stuff, and I get lost in it, to be honest with you. So if you can explain it in non-lawyerese for knuckleheads like me, I'd really appreciate it.
I'll just go full historian. I'll just nerd out. So
yay, and in English.
Yeah.
What a thought. Okay.
So partially correct. So the 14th Amendment is ratified in 1868. And at the time of the ratification of the 14th Amendment, there wasn't really a discussion about the incorporation doctrine, what we call incorporation, which is incorporating the Bill of Rights or the protections of the Constitution against the states directly. But later on in our history, there start to become Supreme Court opinions where they basically say, look, there are provisions of the 14th Amendment that ensure that these rights are also protected via the 14th Amendment against state interference beyond just federal government interference. And that's where you get this line of cases talking about incorporation. And there's several cases that go down the line that talk about incorporation of the rights protected under the First Amendment, under the Fourth, under the Fifth, and all of these different portions of the Bill of Rights and other federally protected rights that are then, according to the court, protected against state action via the 14th Amendment. So eventually you get that in the Second Amendment context with McDonald, the Supreme Court case that was decided in 2010, where the court basically said those rights protected by the Second Amendment are so fundamental to liberty that they were also understood to be protected under the clauses of the 14th Amendment. So where that becomes relevant in this history conversation is some people argue that because the protections of the Second Amendment were then enforceable against the state via the 14th Amendment, ratified in 1868, that is the day that you should look to contemporaneous history when enforcing the Second Amendment against the states. So that's the whole debate and the whole back and forth on it.
As a layperson, let me just say that's absolute nonsense. If it meant what it meant when it was written and drafted and incorporated into the Constitution in 1791, then it meant that from that moment onward, and whether it was whatever happened with the 14th Amendment in 1868 doesn't change what it means. I mean,
exactly.
I'm just the average Joe, right? Actually, in my case, I'm the average Joel. But I'm going to start calling you Professor Cody when you come on this show, brother, because you got the history down. Okay, so I think I've figured out what that whole argument is. But where is this just an act of desperation on states like California, where they're reaching even beyond that 1868 date? I mean, if they know that it's somewhat agreed upon that at least at minimum the broadest range is 1791 to 1868, but they're reaching sometimes into like 1935 or 1945 or something. Is that just desperation on their part because they can't find something else?
Exactly. Yeah, they're doing that two ways, right? So one way they're going and they're looking at the history that should be discussed, so on and so forth. And so they're trying to stretch as close to modern times as possible because they know that most of the gun control that they want is relatively new in our history, that these things didn't exist 250 years ago. And so they want to get as close to modern history as they can so that they can try and justify their modern gun control laws based on things that were passed in the 1900s. Now, the other thing that they try and do is they try and grip on a quote from Heller talking about certain long-standing, presumptively lawful regulations. And that's them, instead of trying to move the ball forward from 1791, trying to move the ball backwards from today and saying, oh, well, if these laws have been in place for 100 years and they've remained in place and they haven't been challenged, they haven't been stricken, then that should be presumptively lawful because it's a long-standing law. That's equally ridiculous because it doesn't matter how long an unconstitutional law has been in place. If it is unconstitutional, it is unconstitutional. And so it doesn't matter if it's a 100-year-old law. It's also not what the court was saying in Heller. But time is irrelevant. Just because nobody's challenged it or it hasn't been stricken down for, a century doesn't magically make it lawful or constitutional. And so they try and do both. They try and push 1791 as far forward as they can, and they try and take today as far backwards as they can to try and get to this point where they're, in this height of gun control laws in the, mid 1900s that are getting passed so that they can use those to justify today's laws.
Wow, it does sound like desperation. Of course, I guess if you get in front of the right judge that doesn't like guns, you can get some of this stuff to fly. Hence the decision coming out of the Ninth Circuit. What's going on in the rest of the nation? For example, is there another similar case somewhere that's close to the one we're talking about? That maybe is it farther along? Are we farther along here in California? And if that one actually gets decided at hopefully the Supreme Court in a positive way, does that affect California? I mean, where do we land in all these other 50 some odd cases you mentioned around the country with the general movement?
So there are several other cases. A lot of the states that you would expect passed laws immediately after Bruin came out, trying to designate a bunch of, vast swaths of land as so-called sensitive places. Some of those cases are further along. Some of those cases are already on the merits. So this is at the preliminary injunction phase, which is basically, for those that aren't familiar, when you file a lawsuit, you can ask for a preliminary injunction or a TRO, a temporary restraining order. And basically what you're doing is you're going into the court and you're saying, hey, we're going to win, but we are going to be so injured during the time it takes for you to decide this lawsuit, judge, that we want you to maintain the status quo, to pause enforcement of the law that we're challenging during the life of the case. And so it's preliminary relief because you haven't officially won the case. You haven't gone through all of the steps. But it keeps the parties whole. It keeps people from being injured, people from incurring, potential damages, people from potentially having to give up property. In this case, it prevents people from not being able to exercise their rights in places that they should be able to exercise their rights. So that's the preliminary injunction phase. That's where this case is.
Okay, so before we move on, I want to make sure that I get that, because that sounds like a mechanism that the court has to prevent government from just willy-nilly creating laws that are going to harm people, knowing full well they're eventually going to get tossed, but doing it anyway, so that the court can then look at that and go, no, that's not going to fly. That's obviously not going to fly. So I'm going to place an injunction on enforcement of that while we go through the court, so that you don't get to torture the citizens with it while we're going through to find out that it's not going to fly. Did I get that right?
You've got it better than some of the judges.
Can I'll judge these cases. I'm good. I know who's going to win every stinking time. No, that wouldn't be good. All right, anyway, I'm sorry I interrupted your explanation, but I wanted to make sure that I got it. So go ahead.
Yeah, you have it exactly right. Unfortunately, it's not always employed that way. So oftentimes the courts will put a really high standard on it. The other problem that you run into is when you're arguing for a preliminary injunction, one of the factors is, public interest and balancing public safety against. So this is where it's unique, right? We just talked about the fact of when you're litigating these cases, when you're on the merits, trying to actually win the case, you can't consider, the public. That is not part of the factor. You are not balancing X versus Y. You are solely looking at text as informed by history. But when you're doing a preliminary injunction, the court is required to do that, is required to balance interests. And so a lot of times judges will go, well, it's irrelevant if they're going to win because I think that, the public interest weighs in favor of letting the state enforce these laws. So it's not always as cut and dry as it should be. But yes, dead on. The entire point of a preliminary injunction is just to prevent states from doing something that's going to hurt people, recognizing that they can slow the wheels of justice for years on end and allow them to hurt people in the interim. And so it is supposed to prevent against that. So this case is on a preliminary injunction posture. There are other sensitive place, so-called sensitive places cases. They're not actually sensitive. That's why I keep saying so-called. I guess I should just explain. Like, they're just locational restrictions, right? They're just banning carry in certain places. Like, the parking lot of a bank is not a sensitive place. I'm sorry. It's just not. Like, these are not. They're just using that moniker to try and make them sound scary so that they can prohibit people from exercising their rights. So there are several other cases that are in other areas of the country. There's one in New York, there's one in Maryland, that are on the merits. And so those cases are, moving at that phase. And so they're a little bit further ahead than California. But you also never know what the Supreme Court is going to take or when, right? You never know if the Supreme Court is going to take, generally speaking, they don't like to take the first case that gets up to them. They say they want the issue to percolate at the lower courts and at the circuit courts. So you could have a merits win. We could strike down a law in New York, let's say, and New York could ask for review and the Supreme Court could say no, right? The Supreme Court chooses the cases that it hears. And then, we could succeed against California. California could ask for a review and the Supreme Court might say yes. So you never know exactly what case or when the court is going to take it. But there are several challenges to these bans across the country. And we've been pretty successful on enjoining and striking them down. I mean, it's
Cody, I've been told in the past that the Supreme Court seems to like conflicts to resolve.
Yes.
So, for example, if you have one case on one circuit and one case in another circuit, and one decides one way and the other one decides the other way, but the similar cases, that the Supreme Court wants to get in there and settle that. Is that the case? Is that true?
Yep, that's accurate. So we call it a circuit split, and that's when one circuit says yes and the other circuit says no, basically. You got it dead on. And so the Supreme Court hears about 1% of cases that it's petitioned to hear every year. And so a lot of times it's taking very specific things. There are things that will make it more likely based on data that the Supreme Court will take. There's things that make it less likely. For example, the Supreme Court just said that in reversing a bunch of cases after the Rahimi case was decided, it said, well, these are all on an interlocutory posture, meaning that they're all on the preliminary injunction phase. Like, we're more interested in a merits case. Okay, well, that's a signal of what the court's more interested in. You also have circuit splits. The court, based on data, is way more likely to grant a case when there's a circuit split. The court is also much more likely to take a case when the government loses. And that seems perverse to most of us. But the reason being is that's the court saying, okay, a federal court has struck down the action of a state legislature. We should take a look at this. It's almost an authority deference in a way. The Supreme Court's also more likely to take a case if a federal law is struck down or enjoined. So, for example, we have a case going to the Supreme Court next month, and that's a case in which we were victorious against the ATF's, framer receiver rule. Right, so we beat down the framer receiver rule at every phase. The Fifth Circuit decided in our favor. Government asks the Supreme Court to hear it. Much more likely that the Supreme Court is going to grant a case where the government lost. So those are all things that kind of factor in. And some of it too is, like I said, the court claims that it wants issues to percolate, which means if something is brand new, the court wants to kind of see how the circuits are going to deal with it, where they're going to go before the court jumps in immediately. So if there's something really new, it's also not very likely that the Supreme Court will dive in. But the counter to that is the Supreme Court will dive in to protect its own decisions at times.
I was just going to ask you about that. Okay,
yes.
So there's also I think there's the interpersonal part of this. A lot of what you just talked about is more legal and technical, I think. But I think we have conservative justices who are getting older. I know Justice Thomas has been wanting to do something with the Second Amendment since 3 days before dirt. And he hasn't been able to do it because he hasn't had the right balance on the court to do it. And now it's there in a lot of ways, or at least we hope. It seemed to be. How much motivation is there, and how much does it change the calculation on what cases they take or don't when justices want to address a certain body of law, or for that matter, when they have addressed a certain body of law, as they have multiple times in the Second Amendment case, and the lower courts simply refuse to follow instruction and do everything they can to obfuscate at every turn if they're leaning toward not wanting to obey the instructions of the court. Does that motivate the court to take those cases to A, straighten that out, and B, go after an issue that many of the justices want to straighten out in the first place?
I think it certainly motivates justices. And the thing that you have to remember at times is, right, so the Supreme Court we refer to as a monolith, but really it's 9 justices. And they get together and as a group decide what cases to take and what cases not to take. So you need 4 justices to vote for granting cert in a case, for agreeing to hear a case. By tradition, they do that. They take the vote twice. They make sure they have at least 4 justices twice. But you need 5 to win. So there is some, back and forth on that front. You might have 4 justices that all agree that they want to hear a case. Hey, this is a big problem. We need to deal with this. But if you don't have 5 justices that are going to rule the way that, you want to, then strategically, do you want to force the court to hear the case if you know that it's going to go the direction that you don't think it should? So there's probably significant amount of back and forth on that point in getting cases heard. What do these justices care about versus what does the court writ large care about? What do some justices not want the court to ever touch? And how that all plays out, because there's also back and forth on who writes the opinion, right? And that changes that as well. It depends. So if you get 4 votes, but you aren't going to have 5, then you might not want it heard. If you have 5 votes, if the Chief Justice is in the majority, at least 5-4, then the Chief Justice assigns who's writing the opinion. If the Chief Justice is not in the majority, then the most senior member of the court gets to decide. Currently, that's Clarence Thomas if he's in the majority. So you get this weird back and forth, too, of do they grant a case, do they not? What are they considering when they grant it? And then once they hear it, who gets to write the opinion? And then they have to write it in such a way as to keep a coalition together, because if somebody splits, then somebody else gets to write it. So there's a lot behind the scenes at the court that we don't often talk about because we think of the court as a monolith at times. And so those are all factors that are going to play into whether the court hears or decides a case or not, and how willing they are to defend their own, precedent. I think in our space, in the Second Amendment space, it seems pretty clear that they're willing to weigh in again. I think they're just waiting for the right case now. But we had Heller in 2008, then McDonald's in 2010, and then utter silence from the Supreme Court. You have this intervening opinion in Caetano, which was a per curiam, just, hey, you guys did it wrong. That's in 2016. You don't have another case get up to cert granted until the original New York State Rifle and Pistol Association versus City of New York, which was the case, if you remember, that got mooted out because the city changed its ordinance that was being challenged. And then New York State magically passed a law prohibiting the city from reenacting the ordinance that was challenged. Yet they had
I wonder how that happened.
Weird.
Strange, yeah.
They've been defending it for a
totally
decade.
Unpredictable.
Yeah, random. Just a complete change of heart, really. So that seemed to be the next case. Then it gets mooted out. And then immediately next term, they granted in New York State Rifle and Pistol Association v. Bruin. Immediately after Bruin, then you get Rahimi, which is an opinion. Yeah, but you could see that they're now, okay, they took City of New York, mooted out. Okay, then we're going to take Bruin, decide it. Okay, we're going to take Rahimi, decide it. There was also all of these Administrative Procedure Act cases going up, right? You've got bump stocks was just heard by the court in the Cargill case. We've got our case going up next month, the Vanderstock case dealing with ATS frame receiver rule. There's the pistol brace rule that's sitting that's just moved to the Fifth Circuit. The federal government just appealed our victory at the district court. So these are cases that are tangentially touching guns, right? They're some more so than others, but they're ATF authority cases basically. And the court's been willing to take those as well. So I think the appetite is obvious. And I think it's a matter of time. We have a petition before the court right now. Case is called Snope. It deals with Maryland's so-called assault weapons ban. And that is, since the court said that they wanted a merits case, that is the first merits case to go before the court on petition, where it deals with the straightforward question of, can Maryland ban common semi-automatic rifles? And so I think that case has a really good likelihood of being granted, and we're really hopeful that the Supreme Court will take and hear that case.
Yeah, me too. You mentioned administrative state stuff.
Yeah.
The court has gone after the administrative state, not just where the Second Amendment is concerned. They had a case against EPA. They seem to be wanting to clean up that mess. So many of these administrative agencies suffer from corporate capture, where they've been captured by, the very people they're supposed to regulate. Do you see that the court is really going after this? Is this a desire of the court to go after the administrative state? And even if they do things with EPA or whatever, does that help us when we're dealing with ATF and other administrative agencies?
Absolutely, on all fronts. I think the court has made it clear that it's not okay with the administrative overreach, the current court at least. And this dates back years and years. I mean, there was a case a few years ago called Kaiser v. Wilkie, which dealt with the question of hour deference, which a lot of people weren't familiar with. It's basically like the little brother of Chevron deference. It's either Seminole Rock deference or hour deference, depending on which case you point to. But in that case, even the court didn't get rid of hour deference. It just basically left it on life support. I think Gorsuch, in a concurring opinion, called it like a walking zombie at this point. But this has been an appetite of the Supreme Court for some time now to really dial in some of these doctrines that had evolved around the administrative state, which is, deference on interpretation of their own internal regulations, deference on which is our deference of interpretation on statutory regulations, which is Chevron. You have major questions doctrine, which is that EPA case, which is saying, basically the quote from Scalia is, Congress wouldn't have hidden elephants in mouse holes. Basically, they wouldn't have hidden big administrative power in tiny, minute statutes, which a lot of agencies were pointing to. So these are all marching in that direction. And then you have the Cargill case, right, where the Supreme Court says, no, as a matter of statutory language, a non-mechanical bump stock is not a machine gun, something that we knew all along, right? So you are seeing the court being a lot more willing to weigh in and dial this power of the administrative state back a little bit, and really just try and put the power back in the hands of Congress, because that's how our system of government was designed.
Well, okay, and you bring up a great point. And unfortunately, I'm 66, and I hate that age because my birthday's in June, so it's 3 6s, which as a Christian really bothers me. I can't wait to be 67 just to get rid of one of them, okay? But when I was in school, they had civics in high school, which they don't have anymore, and they haven't had for decades, and that was a class in which you learned how your government works. And so we have entire generations of Americans now who, unless they go study it on their own or they take a class in college, have no clue how our government works. It seems to me, and correct me if I'm wrong, that the whole drive to use the administrative agencies to create rules that have the effect of enforce of law that are outside the four walls of the statute, if you want to call it that, or the boundaries of the statute, is because the administration couldn't get that through Congress, because you got to get it through the Senate, you got to get it through the House, they got to go to conference, they got to both. Passing bills and making laws in the United States Congress is by nature difficult. It was designed to be difficult. So this is a way to completely bypass Congress and create rules that have the force and effect of law without going through that difficult process, because you know you're not going to get it passed if you do. That's been going on for a long time, and that strikes me to be exactly what's happening. So I'm encouraged that the court is starting to chip away at that. How far do you think they'll go?
I don't see an end in sight on this. I think that here's the big question, right? Something you mentioned earlier on is a couple of the justices are getting up there in age, and they probably won't remain on the court for too much longer. We don't know how, you have no idea how long. So, as the composition of the court changes, who knows what changes on that front. But as of right now, in the current court, they don't seem like they're interested in slowing down. I mean, we have obvious statements from the administration. I'll go back to the Vanderstock case. They specifically tried to get Congress to pass a law regulating these so-called, weapons parts kits or frames or receivers, like 80%ers is, what we would call them. And they tried to get Congress to pass, and it failed, and it failed, and it failed. And then next thing, Biden gets elected, and he stands in the Rose Garden, and he goes, I order Merrick Garland immediately to work with ATF to promulgate a rule that regulates these so-called, they like to call them ghost guns. And so they knew they couldn't pass it through Congress, and so they did it through executive action, and did it through a rulemaking. And that's, how much history you want to go into. That's the design of bureaucracy is the idea that well-educated specialists know better how to regulate and drive your life than you do. The entire system is designed around ceding power to so-called well-educated specialists, bureaucrats, who are trained in their area and know better than you how you should live your life. And that's the system has been pushed for that for decades. Congress doesn't pass laws because you have to expend too much political capital. And it makes it a lot harder to fundraise if you expend too much political capital to get a law passed. And they want to fundraise and they want to stay in office. And so
wait. Let's define political capital. In other words, what you're saying in regular language that the average construction worker, I came out of high school and went right into the masonry business. So I used to build block walls and all that kind of stuff as a young man. That was my trade, was the masonry trade. So I'm the average construction worker. Just in the language of the average construction worker, what you're saying is they would actually have to do their job. That's the political capital. And because they don't want to have to do their job because it would take them too much time, they'd rather spend time getting reelected, they don't pass laws. So can we just speak English here? They don't want to do their job, which would take them too much darn time. So they'd rather be out running for reelection. Is that what you're saying?
Yeah, my dad would be...
Okay, yay, I got it. Hallelujah, okay. There you go.
My dad would be really disappointed in me. I grew up in a machine shop, so I'm there with you. I just happened to end up at law school somehow.
Yeah, but you went to law school, man. I get it. I went to college, but I didn't graduate. I actually had a job, so I just went back to work. So you're ahead of me in the whole... And you got to deal with this legal beagle language all the time. So I'm just speaking English. Forgive me, I speak English, Spanish, and Cash. My English sucks. My Spanish is worse. Cash, I speak fluently. So, there you are. So that's it. But that helps me. So it's not, political capital is just a buzzword for they don't want to invest the time and energy in doing it.
Yeah, and potentially lose a re-election bid, right? If you're in the House, you have to get re-elected every 2 years. As soon as you win re-election, they don't immediately go, okay, now I can go and work on this law that I really want to get passed. They go, hey, we need to start fundraising for the next election cycle. They start as soon as they get elected because they only have 2 years. And so the last thing that they want to do is work on and get an beneficial bill.
And do their job.
Yeah.
For which they're getting paid reasonably well, that's crazy. That's crazy. All right, so two things I'm going to ask you. Last question, and then I want you to tell us how we can support the organization FPC that you work for, Firearms Policy Coalition. You guys are doing a great job, and I want to promote you if I can. All right, last question here, and this is getting political now. We're in election season. What do you got? 67, 68 days to go. How important is this presidential election from the standpoint of maintaining the rights we have and restoring the ones that we don't?
So I think that one of a bit of a cop-out answer, but I'll tell you it's a cop-out answer as I started. So I have coverage.
You're an attorney. What the heck?
Yeah, well, maybe. No. It depends.
It's okay. It's all right. Go ahead.
One of the reasons that we do our work in courtrooms is because it's all about ensuring that you have long-standing applicable precedent. And that is incredibly important. And making sure that you have legal victories that can outlast elections and can outlast politicians is incredibly important. What I will say is that I think it's becoming more and more clear as we go through whatever timeline we have found ourselves in. Presidential elections have become to be about the Supreme Court. And we're at a place now where the last several elections, right, the big looming question is the Supreme Court. What happens? What judges leave the court? What judges join the court? How willing is someone going to be to expand the number of the court? Right, the Constitution doesn't set a number of justices for the Supreme Court. It contemplates that there's at least one, because it speaks specifically about a Chief Justice. But those are all really open questions. And so I think that's become the biggest thing over the past, I don't know, 12 years probably, is that the presidential election has become about the Supreme Court. And I think that's a huge problem. I mean, I think part of the problem is we've gotten to a place where we let, the way that we think about it as a people, not you and I, but just generally speaking as people, is we think about rights as government granted, right? People talk about your Second Amendment right. You don't have a Second Amendment right.
No, you have a right guaranteed by the Second Amendment that is your God-given, or if you want to call it the natural right, everybody has.
Exactly. And that's a universal truth. That is a basic truth. And until we get to a place where we can go back to that, where people are no longer talking about Second Amendment rights and those rights that government has given us, right? Then I think we're going to continue following in this problem where government does so much, it touches so many things, that the Supreme Court has become so important. And I don't know how we found ourselves in this timeline, but I guess it's the one that we're in. And so I expect that the court and the composition of the court is going to be a major conversation surrounding this election.
Yeah, I think how we got here is a philosophical debate or discussion that you and I could start today and end sometime the end of next month. We could talk about that a lot. I've been around a while, so that would be an interesting thing. It would actually be a very interesting discussion. When we'll have to do this, maybe we'll have to do that over coffee or beer or something. I don't know.
I'm always happy to talk about the foundings of bureaucracy coming out of the Civil War, leading into
oh my gosh.
Wilson. Yeah, that's you know.
So is it just the Supreme Court that we're worried about, or is it also just federal courts in general? Because the president appoints judges. Of course, the Senate has to confirm them. And it's, in my memory, it's very unusual for a president to have, in that president's party, whatever it is, I think they're all the same at this point, but nevertheless, you know, for a Democrat president, for example, to have both the House and the Senate, or a Republican to have both the House and the Senate under the same party, is quite unusual. Mm-hmm. And I think that's part of the balance of power, and the way the two houses function is very, very different. As you mentioned, their cycle of election is very different. Their focus is very different. The Senate is supposed to be a more deliberative body, and the House is supposed to be absolute chaos, and it is. And that makes it harder to accomplish things, which was, again, the brilliance of our founders by design. So regardless of who becomes president, I look at what the court is doing in reining in administrative states so that the president doesn't have as much power to just make things law by fiat. I'm going to write an executive order and make this happen, is very positive, because we begin to restore the functioning of our representative Republican government. And I'm not saying Republican from a party perspective, but we don't live in a pure democracy. We live in a representative republic. It's quite different than a pure democracy. Thank God we don't live in a pure democracy. We'd be in deep trouble. Do you see this as positive? I mean, this is one of the concerns, I think, is is, let's say, for example, let's say, for example, Kamala Harris becomes president. She might appoint a lot of judges we don't want, but if the Senate goes the other way, she's going to have a tough time getting them confirmed. And so that's the bulwark against that. What are your thoughts on that, and where do you see positives in that? I want to kind of like to leave the conversation in a positive vein if I can, and then I want to know how we can support FPC.
Yeah, I think you're dead on, and you're hitting on something that has become almost a taboo subject at times. But government isn't designed to be efficient or quick, right? Our system isn't designed so that it is convenient to do things. It's supposed to be hard and difficult, and it's supposed to be a battle, because then the idea is that the best ideas will rise to the top and we'll get agreement. That's the entire purpose of our system of government, essentially. So I don't think it's a bad thing when you have, deadlocks and when you have slowdowns and when you've got this push on government. I think that's a good thing. I also think that's why it is so important that the court is reigning in the administrative state and is reigning in the executive branch, because when those deadlocks happen, the executive branch has now just pushed it to the administrative state. They go, well, we don't want to deal with the deadlock in Congress, so instead ATF, EPA, the original BLM, Bureau of Land Management, Forest Service, you guys deal with it. You guys figure it out. You guys make the rules. And then everybody's going to be bound. I think, disabling some of these precedents that have been around for 40 and 50 years that are just wrong, like Chevron deference, is hugely important on that front. And that's where I see there being a positive. I do think that, if there's a deadlock in government, that's not a bad thing. It's a good thing to ensure that the cream rises to the top, that you get the best ideas, you get the best push forward. And that's also why we've got 59 active cases across the country. It's because we're fighting this issue on every front. And that's incredibly important, because sure, one judge in one court in one circuit might not agree with you. But if you have 3, 4, 5 judges in different courts and different circuits agreeing with you, then it shows, okay, this is where this really stands. This is really where the state of the law is and where it should be, and then really pushes that envelope forward. So that's why litigation is so important. And that's why having a comprehensive strategic litigation plan is so important.
Well, I think the Chevron deference case that you mentioned, that whole thing being tossed by the Supreme Court, now puts you at FPC in a position where the judge cannot just say, well, ATF said so, and so we're going to find in favor of the government. It doesn't work that way anymore.
Makes it a fair fight.
I mean, you got to lay right. You got a little bit of a fair fight you didn't have before. Well, listen, brother, thank you very much for coming on the show. I hope you will come back. How can the folks that are watching, how can they support FPC?
Absolutely. So for FPC, you can go to firearmspolicy.org. You can click on that join button. You can become a member of FPC. That's the best way to support the work, to be a partner in what we're doing. You can also follow FPC at Gun Policy on just about every social media platform. And then for FPC Action Foundation, we're fpcactionfoundation.org. You can join, you can see our work there. You can donate, support the work on that end. And then we're at FPC Action on social medias, and you can follow us there.
Well, they can follow you on X as well. I did today. I wasn't following you before, but now I am. Okay, so there you go. Hey, man, thank you very much for coming on. Thank you for playing Professor Cody today. You educated me a lot. I'm really grateful. And let's do it again, okay?
Absolutely. Thanks for having me. It was a pleasure.
You bet. Have a great week.
You too.
Thank you very much for watching the entire interview. I'm very grateful that you did. One more time, I'll remind you, X, Rumble, links in the description. Please go over there. YouTube is, well, YouTube. And please support FPC, if you wouldn't mind. And you should follow Cody. If I can figure out how to put a link to that for his Twitter feed, I'll do that. And follow FPC. Great organization. Please support them. Thank you so very much for all of your support of Gun Guy TV. I am extremely grateful to you. Without you, this would be a useless effort, and I would be wasting my time. So I'm very glad to have you here. Please, wherever you go, whatever you do, stay safe.